Welcome to the deep dive. Today we're tackling the surprisingly complex world of unfair trade practices.
Yeah, it seems straightforward sometimes, but isn't.
Exactly. And we're specifically honing in on dumping. It's a word you hear a lot in trade news. Maybe sounds simple.
But it really isn't.
Yeah.
There are layers there and big real-world consequences.
Right. On the surface, selling stuff cheaply overseas seems fine. But the international rules, how they define it, how they deal with it.
Oh, yeah, that's where you find the really fascinating details. And you see the impact, on local businesses, global trade, everything.
Okay, so our mission today, our deep dive, is to really get to grips with what dumping actually is,
Uh-huh.
how the WTO rules try to sort of manage it, and why it's still, such a hot
A
topic.
really contentious issue, yeah.
So whether you follow trade closely or this is all pretty new, we're aiming for a clear path through it. No jargon, just the core stuff.
Sounds good.
Okay, let's start right at the beginning then. From the WTO's point of view, what is dumping?
Okay, so the WTO's anti-dumping agreement, Article 2.1, basically says dumping is when a product gets exported to another country at a price that's lower than its normal value.
Lower than its normal value.
Yeah. But here's a really key point right away. WTO law doesn't actually forbid dumping itself.
Oh, interesting. So it's not illegal per se.
No, not illegal in itself. What the rules do is provide a framework. They let member countries take action against dumping if, and this is the big if it's causing harm to their own industries.
Right, okay. So it can trigger response, but it's the harm that's key. You mentioned normal value. What is that? What's the yardstick?
Normal value is, well, it's the benchmark price, essentially.
Okay.
Generally, it's the price for the same or very similar product. They call it the like product when it's sold in the exporter's own home market.
Ah, the domestic price.
Exactly. And it has to be under what they call ordinary trading conditions.
Ordinary trading conditions. What makes a sale ordinary?
Well, several things need to line up. It has to be a normal commercial deal, part of the ordinary course of trade.
Right.
The product, as I said, needs to be identical or very similar. The like product. And it should be intended for sale, for consumption in the exporting country itself. And the prices should be, comparable to other similar domestic sales.
Okay, so they're looking for genuine, typical home market sales. What wouldn't count then? What's not in the ordinary course of trade?
Good question. Think about sales between related companies, like subsidiaries.
Ah, yeah, those prices could be artificial.
Exactly. They might be influenced, so they're usually checked out. Same goes for sales made below the cost of production. Generally, those are disregarded.
The low cost. Okay.
Yeah, or transactions where the price is like abnormally high or low, things that just don't seem to reflect normal market behavior. The whole point is to find a reliable market-based price in the exporting country.
Makes sense. And you mentioned product. Does that have to be absolutely identical?
Article 2.6 clarifies that.
Mm-hmm.
Primarily, yes, it means an identical product.
Okay.
But if there isn't an identical one sold domestically, then it can be a product that has characteristics very, very closely resembling the one being exported. So there's a bit of flexibility, but it has to be really similar.
Got it. So you've got this normal value from the home market and the price it's being exported at. But surely you can't just compare the price tags directly if the sales conditions are different.
No, absolutely not. And that's crucial. Article 2.4 talks about the need for comparability.
Comparability.
Yeah, it means you have to make adjustments, fair allowances for anything that could affect the price difference, but isn't actually about the dumping itself.
Like what sort of things?
Oh, things like the level of trade. Are you comparing the ex-factory price with a retail price? That would be fair. The timing of the sales, any physical differences in the products, even if they're like products, the terms of the sale, like who pays for shipping, payment terms, and even differences in taxes. All these need adjusting to get a proper apples-to-apples comparison.
Okay, wow. So a lot goes into establishing that normal value fairly. Now, what if you just can't find a good domestic price to use? You mentioned scenarios where that happens.
Yes, exactly. There are a few main situations where the domestic price just isn't suitable. One is, like we touched on, when most of the domestic sales are below the cost of production over a period of time.
Right, the below cost sales.
Another is when there are just too few sales or maybe even no sales at all of that product in the ordinary course of trade back home.
Not enough data, basically.
Pretty much. And the third one, this one's caused a lot of debate, is if there's something called a particular market situation.
Particular market situation. That sounds potentially broad. How's that usually interpreted?
Well, It is a bit open-ended. A WTO panel looked at this a few years back in a case involving Australia and A4 paper.
Okay.
They suggested it needs to be something, distinct, specific to that market, and it has to affect price comparability. It makes the domestic price unreliable as a benchmark.
So something unusual happening in that specific market.
Yes, something that distorts the prices there. But the panel also said, look, you can't make an exhaustive list of every possible particular market situation. It really depends on the facts of the case.
That flexibility could be tricky. Could be used protectively, maybe.
That's certainly the concern some have, yes. That it could be a loophole to justify higher duties when maybe the domestic price should have been used.
Okay, so if one of these situations applies below-cost sales, not enough sales, or this particular market situation, how do they figure out the normal value then?
Article 2.2 gives two main alternatives.
Right.
One option is to use a representative export price. So the price the exporter charges when selling the same product to a different suitable third country.
Ah, find another export market price.
Yeah, the idea is to find a market where the price is hopefully less distorted and use that.
Okay, what's the second option?
The second method is to construct the normal value.
Construct it. How?
You basically build it up from scratch. You take the exporter's cost of producing the goods,
Uh-huh.
then you add a reasonable amount for administrative, selling, and general cost, SG&A they call it.
Right.
And then, crucially, you add a reasonable amount for profit.
So cost plus overheads plus profit.
Essentially, yes.
Yeah.
That gives you a constructed normal value.
Okay. Now, what about economies where the government has a really heavy hand? Non-market economies. How does dumping work there? Domestic prices might not mean much.
That's a really, really important point. In what they term non-market economies, or NMEs, where the government heavily influences or controls prices and trade,
Yeah.
those domestic prices are generally considered unreliable for calculating normal value. They don't reflect market forces.
So what do they do instead?
In those cases, importing countries often use the analog country method.
Analog country.
Yes. They find a market economy country, the analog, that's at a roughly similar level of economic development.
Okay.
And that also produces the like product. Then they use the prices or costs from that analog country to figure out the normal value for the exports coming out of the non-market economy.
Wow, that sounds like it could be quite controversial. Choosing the right analog country seems critical.
It definitely can be. Picking an appropriate analog is often a point of contention in these investigations.
Can you give an example?
Sure. There was a big case, EC Fasteners, China, back in 2011. The European Commission decided that fastener prices inside China were distorted by government influence.
Right.
So to work out the normal value for Chinese fasteners being exported to the EU, they looked at prices of similar fasteners made and sold in India. They decided India was a suitable market economy analog country in that case.
Okay, I see. So that covers normal value. What about the other side, the export price? Is that just the price tag on the invoice?
Usually, yes. The export price is generally the price the exporter sells at to an independent buyer in the importing country. Pretty straightforward. But Article 2.3 acknowledges that sometimes the exporter and the importer might be related, maybe part of the same company group.
Ah, like the internal sales point earlier.
Kind of, yeah. If that relationship affects the transaction price, makes it unreliable,
Then what?
then the rules allow the investigating authority to construct the export price too.
How do they do that?
It might be based on the price at which the imported goods are first resold to an independent buyer in the importing country. Or, if that doesn't work, maybe on some other reasonable basis, again, trying to find a reliable price.
Okay. So you've painstakingly determined a normal value and an export price. How do you actually calculate if dumping is happening and by how much?
Right. The gap between the normal value and the export price, that's your margin of dumping.
The dumping market.
Exactly. Article 2.4.2 lays out the standard ways to compare the two. The most common are either comparing individual export transactions to individual domestic sales.
Transaction to transaction.
Yes. Or comparing a weighted average normal value to a weighted average export price over a period.
Weighted average to weighted average.
Correct. There is also a third, less common method, comparing a weighted average normal value to individual export transactions.
When would they use that one?
That's allowed in specific situations, mainly if there's a pattern of significantly different export prices across different buyers, regions, or time periods, what's sometimes called targeted dumping. And the average-to-average method might hide it.
Okay. Now, there's this term you hear all the time in dumping discussions. Sounds a bit odd. Zeroing. What on earth is that, and why is it such a big deal?
Ah, zeroing. Yeah, it's been hugely controversial. It's a calculation method some countries use when working out that overall dumping margin we just talked about.
How does it work?
Okay, let's use an example. Say our Alpinian smartphone maker, Alphone, sells phones at home for $500. That's the normal value.
Right.
Sometimes they export them to Industria for $400. That's a $100 dumping margin on that sale, $500, $400.
They're dumping there.
Yep. But maybe they also run a promotion and export some phones for $550. In that case, the export price is higher than the normal value. The difference is negative $50. You could call it negative dumping.
Okay, selling for more than the home price.
Exactly. Now, with zeroing, when you calculate the overall dumping margin across all sales, you treat any of those instances of negative dumping like that negative $50 as if they were zero.
You just ignore the sales where they weren't dumping.
Precisely. You don't let the negative margins offset the positive ones.
But that seems unfair. It would inflate the overall dumping margin, wouldn't it?
That's exactly the criticism. It absolutely inflates the overall margin. In our Alphone example, if they sold half at $400 plus a $100 margin and half at $550 margin, the true average margin is plus $25. But with zeroing, the manatee $50 becomes $0, so the average margin calculation comes out as plus $50.
Wow, double what it actually is.
In that simple case, yes.
Yeah.
It makes dumping look worse than it might be, and it can lead to higher anti-dumping duties being imposed. Exporters obviously hate it.
I can see why. Has the WTO weighed in on zeroing?
Oh, repeatedly. It's been the subject of tons of disputes. Cases like EC Bedlinen, U.S. zeroing, EC, many others.
And the verdict?
The WTO's highest body, the appellate body, consistently ruled that zeroing, pretty much however you do it, violates that fair comparison requirement in Article 2.4.
That's generally not allowed.
That was the clear trend. However, there was a bit of a twist. A panel ruling in 2019 in a case called U.S. differential pricing methodology
suggested that maybe, just maybe, zeroing could be permissible, but only when using that third comparison method, weighted average to individual transactions, specifically to tackle that targeted dumping issue we mentioned.
Ah, okay, so a potential narrow exception.
Potentially. But that finding itself is still debated, and the appellate body isn't currently functioning to give a final say. So the zeroing saga isn't completely over, but the broad consensus is against it.
Okay, super complex. So let's recap. Dumping itself isn't illegal under WTO rules.
Correct.
But if it's found to be happening and it's hurting the domestic industry in the importing country,
Yes.
then that country can take action, can impose anti-dumping measures.
Yeah.
What are the specific conditions they need to meet?
There are 3 crucial conditions, and all must be met. First, you have to demonstrate dumping is occurring using those methods we discussed.
Okay, dumping proven.
Second, the domestic industry producing the like product in the importing country must be suffering material injury, or at least facing a threat of it.
Material injury, got it.
Well,
And third, there needs to be a causal link. You have to show that the dumped imports are actually causing that injury.
dumping, injury, and a causal link. All 3.
All 3 are essential.
Let's break those down. Condition 2. Material injury to the domestic industry. Who counts as the domestic industry? Is it every single company making that product?
Not necessarily. Article 4.1 defines it generally as, well, either all of the domestic producers of the like product,
Okay.
or alternatively, those producers whose combined output makes up a major proportion of the total domestic production.
A major proportion. How much is that? Over 50%?
You'd think so, but interestingly, no. The appellate body, again in that EC Fasteners case, clarified that the major proportion doesn't automatically mean a majority.
Really?
Yeah, it just needs to be a significant enough slice of the industry so that examining them gives a reliable picture of the whole industry's health. You can't just look at a tiny fraction, but it might be, say, 40% or 45% depending on the industry structure.
Okay, so a substantial chunk, but not necessarily most. And what about the injury itself? What qualifies?
Article 3, footnote 9, defines injury pretty broadly. It could be material injury that's already happening, or just a threat of material injury looming on the horizon, or even material retardation of the establishment of a brand new domestic industry.
Okay, 3 types. And material injury is at a high bar.
It's considered a lower threshold than serious injury, which is a standard used for different trade measures called safeguards. So material means significant, but not necessarily devastating.
Right. How do investigators figure out if material injury is actually happening? What do they look at?
Article 3.1 says it has to be based on positive evidence and an objective examination. They look at two main things: the volume of the dumped imports and the effect those imports are having on prices in the domestic market.
Volume and price effects.
Yeah. And then, critically, the impact of those imports on the domestic producers themselves.
How do they assess volume and price effects?
Article 3.2 gets more specific. They have to consider, has there been a significant increase in dumped imports, either in absolute terms or relative to domestic production or consumption?
Okay, volume increase.
And for prices, have the dumped imports significantly undercut the prices of the domestic-like product?
Price undercutting.
Or have they depressed domestic prices, pushed them down? Or suppressed them, prevented price increases that otherwise would have happened?
Depression or suppression.
Right. And the WTO rulings emphasize you need to really show the effect the dumped imports had on those prices, not just assume it. Establish that link.
What about the impact on the producers? What specific things do they examine there?
Article 3.4 lists a whole range of economic factors they must look at. It's a mandatory checklist, essentially.
Such as?
Things like actual and potential declines in sales, profits, output, market share, productivity, return on investments, how much of their production capacity they're using.
Okay, the core business health indicators.
Exactly.
Yeah.
Plus factors affecting domestic prices, the size of that dumping margin we calculated earlier, and negative effects on cash flow, inventories, employment levels, wages, industry growth, and even their ability to raise capital or invest.
That's a comprehensive list.
It is, and it's a minimum list. They can consider other relevant factors too.
Okay, what about the threat of material injury? How do you prove something that hasn't quite happened yet?
Good point. Article 3.7 says a threat determination can't be based on mere allegation, conjecture, or some remote possibility.
Needs to be solid.
Yes, it has to be based on facts showing that a situation where dumping will cause injury is clearly foreseen and imminent.
Foreseen and imminent,
Like maybe there's evidence of a significant rate of increase in dumped imports, suggesting they're likely to jump substantially in the near future, or maybe the exporter has a lot of spare capacity or inventories are building up.
okay, concrete signs.
Yeah. The Mexico corn syrup case confirmed that while you're predicting the future to some extent, it has to be based on clearly foreseen and imminent events, not just vague worries.
And the third type, material retardation, hindering a new industry.
Right. This applies when dumped imports are basically stopping a new domestic industry from getting off the ground.
How do you show that?
Article 3 requires convincing evidence that the industry is actually in the process of being established. Things like they have solid plans, maybe they've started building a factory, or they've already ordered major equipment.
So proof it's a real venture being hampered.
Exactly. A case involving Morocco and hot-rolled steel highlighted that any assumptions about future developments must be reasonable inferences drawn from credible facts.
Okay, so we have dumping, we have injury or threat or retardation.
Yeah.
Now the final piece, the causal link. How do they prove the dumping caused the injury?
This is often the trickiest part. Article 3.5 requires showing that the dumped imports, through the effects we just discussed, volume, price, are causing the injury.
Do they have to be the only cause?
No, not the only cause, or even necessarily the main cause.
Right.
But they have to be a genuine and substantial cause.
Okay.
But there's a critical flip side to this: the non-attribution requirement.
Non-attribution.
Yeah. This means the investigating authorities cannot blame the dumped imports for injury that's actually being caused by other factors.
So they have to separate out different causes of harm.
Precisely. They have to examine any other known factors that might be hurting the domestic industry at the same time and ensure they don't wrongly attribute that separate injury to the dumping.
That sounds really difficult in practice.
It can be very challenging. Imagine, say, Industria's smartphone industry is suffering. Yes, there are dumped imports from Alpinia,
Right.
but maybe there's also a surge in imports of super advanced, non-dumped phones from another country, Biteria, that everyone wants.
Okay, legitimate competition.
Or maybe Industria just passed tough, new environmental regulations that dramatically increase production costs for domestic firms.
Right, a self-inflicted wound, in a way.
The investigators have to look at the impact of the Biterian phones, the impact of the new regulations, and separate those effects from the impact of the dumped Alpinian phones.
How do they do that separation?
Well, that's the million-dollar question. The agreement doesn't prescribe an exact method. But a key WTO case, U.S.-coded paper, made it clear that authorities can't just list other factors and say, yeah, we considered them, but it's still the dumping.
Not good enough.
No. They need to do a proper analysis, really try to understand the effects of those other factors, and ensure they aren't being counted against the dumped imports. Article 3.5 even gives examples of other factors to consider, like contraction in demand, changes in consumption patterns, competition between domestic producers themselves.
So thorough, objective investigation is paramount.
Absolutely essential.
And I assume the anti-dumping agreement has rules about how these investigations must be run.
Yes, very detailed rules. Articles 5 and 6 lay out procedures for initiating investigations, usually based on a complaint from the domestic industry and how they should be conducted.
Is there a time limit?
Yes, they should normally be concluded within 1 year and absolutely cannot take longer than 18 months from initiation.
What about transparency? Do companies get to defend themselves?
Definitely. Article 12 covers notification and public information requirements, and Article 13 requires countries to have independent tribunals or procedures where companies can seek review of the decisions. The whole system is designed, ideally, to be objective, transparent, give all sides a chance to present evidence and arguments, and ensure authorities explain their reasoning clearly.
Okay. So let's say the investigation is done. They found dumping, injury, and the causal link, separating out other factors. What happens next? What measures can actually be imposed?
If there's a final affirmative determination, the importing country it's not automatic, but they can impose definitive anti-dumping duties.
Duties, like tariffs.
Exactly. Usually it's an ad valorem duty, a percentage of the value of the imported product.
Okay.
Less commonly, it might be a specific fixed amount per unit, or sometimes a minimum import price floor.
Are there limits? Can they just slap on a huge duty?
Now, there are important limits. Article 9 says the duty cannot be higher than the dumping margin they calculated.
Can't exceed the margin. Makes sense.
And Article 11 deals with duration. Duties should only stay in place for as long as and to the extent necessary to counteract the dumping that's causing injury.
How long is that?
Well, there are periodic reviews, and there's a very important sunset review provision. Duties automatically expire after 5 years unless a review determines that ending them would likely lead to dumping and injury continuing or recurring.
A 5-year limit, unless renewed. Okay.
There's also something called the lesser duty rule. It's encouraged, though not always mandatory, for countries to impose a duty lower than the full dumping margin if that lesser amount is still enough to remove the injury.
Aiming for the minimum necessary fix.
Kind of, yeah. And any duties must be applied not discriminatorily. Same rate for all dumped imports found to be causing injury, from whatever source.
What about different exporters from the same country? Do they all get the same rate?
Ideally, no. The rule is to calculate an individual dumping margin for each known exporter or producer.
Okay.
But if there are just too many exporters to investigate individually, the authorities can use sampling to pick a representative group or calculate a weighted average margin for those not individually examined, often called the all others rate. But even then, exporters usually have the right to ask for an individual calculation if they weren't initially selected.
Right. You said definitive duties. Can anything be done before the final decision? The investigation takes up to 18 months?
Yes. If there's a preliminary affirmative finding so, early signs point to dumping, injury, and causation. Articles VIX.2 of the GATT allows for temporary measures.
Like what?
2 main types. First, provisional anti-dumping measures. These are temporary duties or maybe a requirement to post a bond imposed during the investigation itself to prevent further injury while the process continues.
Okay, temporary duties.
Second, exporters can offer price undertakings. This is basically a voluntary promise by the exporter to raise their price or stop exporting at dumped prices so that the injurious effect is eliminated.
They volunteer to fix the problem.
Yes, but the investigating authority doesn't have to accept an undertaking. If they do accept it, though, then no provisional or definitive duties are imposed on that exporter's goods. Articles 7 and 8 of the agreement spell out the rules for these.
So the toolkit is definitive duties, provisional measures, or price undertakings. Is that it? Can countries do anything else against dumping?
That's it. Those are the only permissible responses under WTO law. Any other kind of action specifically targeting dumping is prohibited.
Have countries tried other things?
They have, and they've been challenged. There's an old U.S. law, the 1916 Act, that allowed for civil lawsuits and even criminal penalties for dumping. The WTO ruled that was illegal because it wasn't one of the allowed responses. Another famous one was the U.S. Byrd Amendment, or Offset Act. This law took the anti-dumping duties collected and distributed them directly to the U.S. companies that had filed the complaints.
Giving the money to the competitors?
Essentially, yes. The WTO also found that illegal, again, because distributing the duties like that wasn't a permitted anti-dumping measure under the rules.
Very strict boundaries, then. One last area. Developing countries. do these rules apply differently to them?
There are some provisions for special and differential treatment in Article 15.
How does that work?
Well, the first part says developed countries must give special regard to the situation of developing countries when considering applying anti-dumping measures against them.
Special regard. What does that mean in practice?
Honestly, its practical effect is debated. It doesn't seem to require specific actions throughout the investigation or apply company by company. It's a bit general.
Okay. Anything more concrete?
The second part is maybe more operational. It says that before applying duties that would affect the essential interests of a developing country member, the developed country has to explore constructive remedies, like that lesser duty rule or accepting a price undertaking.
They have to explore it. Do they have to do it?
No. The EC bed linen case clarified that explore means they have to genuinely consider these options with an open mind. But it doesn't force them to accept an undertaking or apply a lesser duty if they decide against it after consideration. So an obligation to think about it, but not necessarily to act differently.
Right. This is all incredibly detailed, and you can really see why countries end up disagreeing about whether the rules are being followed correctly. How do those disagreements get resolved?
That's where the WTO's dispute settlement system comes in, the DSU. Consistency with the anti-dumping agreement is one of the most frequently challenged issues in WTO disputes.
Okay. And is there anything special about how those particular disputes are handled?
Yes, there is. Article 17.6 of the Anti-Dumping Agreement sets out a special, more differential standard of review that the dispute panels have to use when looking at anti-dumping cases. It's different from the standard review in other types of WTO disputes.
More deferential. How so?
Article 17.6 has two parts. Part 1 deals with the facts. It says the panel must check if the national investigating authority's process for establishing the facts was proper and if their evaluation of those facts was unbiased and objective.
Proper, unbiased, objective.
Yes, and here's the key bit. If the panel finds the authority did meet those standards, the panel cannot overturn the authority's factual evaluation, even if the panel members, looking at the same evidence, might have reached a different conclusion themselves.
Wow. So they don't redo the factual investigation.
No. As the U.S. hot-rolled steel case emphasized, the panel's job is to review how the authority established and evaluated the facts, not to be a second fact finder. They give deference to the national authority's findings if the process was okay.
Okay, that's for the facts. What about interpreting the agreement itself, if the rules are ambiguous?
That's covered by Part 2, Article 17.62. It starts by saying, yes, you interpret the agreement using the normal rules of international law, like the Vienna Convention.
Standard interpretation rules?
But then it adds a twist. If, after applying those rules, a provision could reasonably be interpreted in more than one way, if there are multiple permissible interpretations, then the panel must find the country's measure to be okay if it rests on one of those permissible interpretations, even if the panel thinks another interpretation is better.
So if the country's interpretation is legally plausible, the panel has to accept it.
Essentially, yes. As long as it's a permissible reading of the text within the bounds of treaty interpretation rules, the U.S. continued zeroing case confirmed this. However, interpretations can't contradict each other. The overall aim is still coherent interpretation.
That really is a special standard, gives national authorities quite a bit of leeway, both on facts and law.
It does. It reflects a balance struck by the WTO members when they negotiated the agreement.
Well, this has certainly been a deep dive. We've gone from the basic definition of dumping all the way through injury, causation, investigations, measures, and even the special rules for disputes. It's incredibly layered.
It really is. We've seen dumping as selling below normal value, but it only becomes actionable under WTO rules if it's causing that material injury, and the causal link is proven through a complex investigation.
And the rules around how you determine injury, how you separate causes, how you calculate margins, the limits on duties, very specific.
Extremely detailed. And as we noted, the whole process is governed by these international rules designed to provide some predictability, but also leaving room for interpretation and inevitably disputes.
And that fundamental question we started with, is dumping really unfair? That debate clearly continues. You have domestic producers feeling harmed, but then consumers and other industries might benefit from lower import prices.
Absolutely. There are always different perspectives, different economic interests at play. It's rarely black and white.
So maybe a final thought for you, the listener, to chew on. Considering just how intricate these rules are and how often countries end up fighting over them at the WTO, does this whole anti-dumping system actually strike the right balance? Does it effectively protect domestic industries from genuinely harmful dumping? while still allowing the benefits of trade, like competition and lower prices.